Hi, this is Kip from Malik and Malik. Today I'm going to be talking about another VSSR mandamus case. And before I get into the details of this particular mandamus, I just want to emphasize with these VSSRs, the violation of a specific safety requirement, that VSSR aspect, the specific, the specific wording in the VSSR, it's kind of what VSSRs are all about. It's not about that you got really injured really bad, or there was this situation and the employer did something wrong. The key issue is, does your injury fit within one of the Ohio administrative codes? The way you got injured, is it listed there? And if it doesn't fit within the Ohio administrative code, the VSSR section of the Ohio administrative code, then there's no VSSR, unfortunately. So, and that's kind of what happened in this case. So what it is, it's a mandamus case. It's actually a Supreme Court case, and what ends up happening is you could appeal these things as of right. If you lose your mandamus in the 10th district, you could appeal it up to the Ohio Supreme Court. Sometimes they'll hear arguments regarding the mandamus. Sometimes they'll just look at what you've written and then they'll issue a decision, just a decision on paper, whatever. So this is one of those situations where this individual suffered a really bad injury and then filed a VSSR, and then their VSSR was denied at the SHO, at the Industrial Commission. So they filed a mandamus. The magistrate affirmed essentially the decision of the SHO, and then they went ahead and filed it to the Supreme Court. So what ended up happening in this it's Levitin versus Industrial Commission, and it was I'll give you the case site under the in the description of the video, but it was decided October 4th of 2023, and the injured worker's name is Miss Levitin, and essentially she crushed her hand in a die cutter machine. She filed a VSSR, and she specifically cited the following Ohio Administrative Code section. And that's what you have to do when you file these applications for VSSRs. You cite what VSSR the employer violated, or what you're alleging the employer violated, which caused your injury. And it's OAC 4123 1-5-01B94. And again, I'll put this site in the description under the video. And this applies to nit points, and that's the point or points at which it is possible to be caught between the moving parts of a machine, or between the moving and stationary parts of a machine, or between the material and the moving part or parts of a machine. So basically, there's these nit points, these things, and it's like where there's moving parts, your digits, your hand can get, crushed or get stuck in there. So what ended up happening? So this die cutter machine at our employer, it had guards at the nit points, and so what would happen is it's kind of like these saw stops. I don't know if you ever used like a table saw. Like if your hand touches the saw, then the saw stop basically stops the blade instantaneously. Similar idea. So when it goes on the nit points, there's a guard. If it touches something, then it would immediately go into shutdown. It would hit that and it stops. That's the idea. So they had this machine had the original guard, and they were kind of getting bowed. I guess they were kind of getting deformed. I don't know if that means they were hitting people all the time or what the deal is, but they were getting bowed, and the company they wanted to replace them because you don't want to have bowed guards. And so the original manufacturer had gone out of business, and this happens sometimes in these instances. So they contracted some other company to make replacement guards, and they ended up making replacement guards. They installed it, and there were some differences. Obviously, they're very close, but they were not the same as the original guards. And one distinct thing that they're different is the original guards were 25 pounds in weight, and the new guards were 39 pounds in weight. So they install these guards on the machine. No issues for a while, and then 10 months after they install these guards, the injured worker, Levitin, is working. Her hand got caught in a roller, and then the die press came down, and the guards on the press did not trigger a shutdown, and her right hand was crushed. So horrible injury. I can't even imagine losing a digit, let alone a hand, let alone the right hand. Like I don't know if I really talk about this, but one of the things that my job is a lawyer, but one of my passions is drawing, 3D modeling, painting, and these sorts of things. So I'm right-handed, so I draw with my right hand. I 3D model with my right hand. So if I lost the use of my right hand, it would be devastating to me. I suppose if I still have my left hand, I would have to learn how to work with that situation. But nevertheless, horrible injury. I wouldn't wish this on my worst enemy. So she files this VSSR, and the Industrial Commission concluded there was no VSSR for the following reasons. First, the maintenance logs of this machine in the months prior did not document any failure or malfunction of the modified guards after their installation. Second, there was no evidence that the modified guard had previously failed. So there was no maintenance logs that documented failure, and nobody had indicated, or there was no evidence, or it wasn't documented by the corporation that they had failed. And so the IC concluded the employer cannot be held for the first time failure of the guard. So this would be the first time it failed. And then the modified guard provided reasonable protection from the nip point. And although it was heavier and less effective than the original guard, it was not equivalent to no guard at all. So their kind of reasoning is like, it's not perfect, but it provides some type of protection, or at least that's the idea. So again, the injured worker filed the mandamus to the 10th District, and then the magistrate affirmed the IC's decision. They filed to the Supreme Court, and essentially the Supreme Court, obviously, spoiler, they affirmed the 10th District's decision, but there's two critical points in the decision, and they say among other things, Ohio does not require an employer's machines to have foolproof safety features. So they don't have to have infallible safety features, and infallible meaning like 100% perfect 100% of the time. So there's some room for malfunction, etc. And the other critical thing, and I really think this is the most critical piece in this whole thing, is nor does it penalize for unforeseeable first-time failures of safety devices. Now, after this happened, I guarantee you that the employer went to great lengths to fix that guard and either replace it entirely or come up with some kind of safety mechanism, which, that's great for who uses it afterwards, but for, obviously for Miss Levitin, it's devastating. But the idea is, and this is kind of what these VSSRs, a lot of these kind of hinge upon, the employer doing something to alter something, and they had knowledge about. You'll see a lot of VSSRs where guards are removed and there's no guard at all. So it's kind of what knowledge does the employer have or can be imputed to the employer about this machine or this process, and does that implicate them in the VSSR? And so again, in this instance, they say, unforeseeable first-time failures of the safety devices. I mean, you get one big error, and it just so happens this error causes this woman to lose her hand. But so that's kind of where a lot of these things, and you'll kind of see this kind of creep on, because VSSRs in workers' comp and Ohio workers' comp law, negligence is never a part of the equation. I mean, we'll have a lot of situations where, like, you'll look at the facts of the underlying injury and you're like, man, that injured worker is kind of the architect of their injury. They kind of did something that you could either qualify as, I mean, for lack of a better term, stupid, but legally it's negligent. What they did was negligent. Their own negligence, their own whatever they did caused their injury. And you'll hear employers who aren't really familiar with the BWC system go to these hearings and make that argument, or at least state that fact. But for the allowance of the claim and these sorts of things, negligence is never a part of the equation. And that kind of but also that's how it gets taken out of the personal injury realm and whatnot. But you get some of these things of negligence kind of concepts. They come back in the VSSR in these VSSR claims, because if a claim is negligent, that is a defense against the VSSR. So that's not a defense against the allowance of a workers' comp claim, but that's a defense against the VSSR that an employer can assert. Bottom line is, at the end of the day, VSSR is, it's obviously you're going to talk to your attorney if you had a serious injury and see if one exists, because it's worth filing them, it's worth investigating them. But the reality is you might not have a VSSR because they're very pedantic, and it's kind of this strict legal construction. They look at every word of the OAC and kind of interpret every single thing, and then they come to the conclusion, that's a workers' comp, that's a VSSR, that isn't. Sadly, Miss Levitin was not awarded the VSSR. But again, at the end of all these workers' comp videos, I always say workers' comp is a complicated beast. And what that means is, if you have a workers' comp claim, I strongly suggest that if you don't have an attorney involved in your case, that you at least consult with one. It's going to pay dividends. Ask your family, friends, neighbor, whomever, priest, preacher, rabbi, etc. Hey, who do you recommend? Do you have an attorney that you recommend that does this sort of thing, or who can you point me to? Otherwise, look on Google. Talk with the workers' comp attorney and get some ideas, at least, about whether or not you need an attorney. Nevertheless, please stay safe, and I do appreciate you watching this video, and this has been Kip from Malik and Malik. Thank you.